The next important law is Constitution. One of the most important enactment law of the land is Constitution. When Constitution came into picture in the year 1950, our Constitution does not consist of separate provisions which deals with environmental matters or environmental protection. The concept of environment was incorporated only in the year 1976 after the 42nd Constitutional Amendment Act, which deals with environmental aspects. The two most important articles are incorporated by this amendment, that is Article 48A and Part 3 of the Constitution, Directive Principles of State Policy. The next is Article 51AG, which deals with fundamental duties on citizens. Article 48A, Directive Principles of State Policy, imposes a duty on the state to protect and conserve our environment. Similarly, Article 51A Clause G imposes duty on every citizen to protect and conserve our environment. There are various other provisions under the Constitution which deals with access to justice with respect to environmental matters. Those provisions are arbitrary state action, violation of fundamental rights, public interest litigation, and fundamental duties. There are other provisions available under the Constitution with respect to environmental matters, arbitrary action against the state, fundamental rights, public interest litigation, and fundamental duties. Let us look into Part 3 of the Constitution, fundamental duties. There are three important articles. Those are Article 14, Article 19, and Article 21. Let us verify each article separately dealing with environmental concern or environmental matters. Article 14 of the Indian Constitution mainly deals with equality before law and equal protection of laws. And nothing was mentioned under this article earlier, but under this article, judiciary interpreted and added a new concept known as arbitrary state action. When a state takes any action, if the state action is arbitrary and causes environmental pollution, a person can approach the judiciary and he can avail appropriate remedy. In one of the cases, that is Bangalore Medical Trust versus Mudappa, in this case, Bangalore Development Authority (BDA) allotted a land for the purpose of construction of a public park. After a few years, BDA converted the land and they want to transfer land for the purpose of construction of hospital. When the Mudappa filed a case before the court, and court held that compared to hospital, public park is more important in cities because people are living in apartments, they cannot get fresh air, and court held that public park is more important than construction of hospital. So this shows that state action, if it is arbitrarily, we can avail remedy under Article 14. The next article is Article 19. Under this article, we can refer to two important aspects, Article 19(1)A and Article 19(1)G. But these two articles are subjected to restrictions that can be imposed by the state under Article 19 Clause 2. Article 19(1)A mainly deals with right to know. Every person in India is having right to know what kind of industry government has given permission, is the industry are good or bad, and he can avail right to information as per Article 19(1)A. This article also deals with other aspect, freedom of speech and expression. The term speech and expression does not include to use speakers and amplifiers which may cause environmental damage due to noise pollution. Article 19(1)G mentions about every person right to carry on his own trade, business, profession, occupation, etc. But if the trade is causing any kind of environmental damage, state can impose restrictions as per Article 19 Clause 2. The most important article is Article 21. This article mainly deals with right to life and personal liberty. The judiciary interpreted the term life and they added many areas which comes or which deals with environment and environmental protection. So this article was interpreted and court held that right to live in pollution free water and air is one of the most important right under Article 21, that is right to live. Besides this, right to health is also incorporated under Article 21. Right to prohibition of smoking in public places is prohibited as per this article because it may cause damage to life of a person. So when a person violates any rights which are known as fundamental nature as per Part 3 of the Constitution, the victim can approach Supreme Court or High Court under Article 32 and 226 respectively to avail the remedies in case of violation of fundamental rights. The court can grant any remedy in the nature of writ even in case of environmental matters. The remedies are mainly mandamus, certiorari, quo warranto and prohibition. Mandamus means the court can inform the person to do or not to do a particular act. Certiorari and quo warranto issued by the court to the lower courts, informing the court to pass on the information or message to appropriate court. The next important remedy available in case of environment matter under Article 32 is public interest litigation. Earlier, the concept is locus standi. Affected person alone can approach the court to avail any remedy before the court. Judiciary interpreted this concept and they evolved a new concept which is known as public interest litigation. Public interest litigation is a tool in the hands of public spirited person. In case of environment matters, any person who is interested to protect the health of the public, he can approach the High Court or Supreme Court by way of public interest litigation and he can avail appropriate remedy to stop such kinds of pollution. Various issues came before the court to deal with public interest litigation and environment. The issues mainly deals with various concepts like public injury, public duty, public interest, social as well as collective rights of the public. So many cases came before the court by public interest litigation and court awarded and gave various remedies in such situation. So various environmental organizations also approach the court to avail the remedy in case of environmental matters. The most important organizations are MC Mehta is one of the most important person who is advocate and he mainly filed public interest before the court to deal with environmental issues and is also known as Green Advocate. Besides MC Mehta, various organizations or associations like Velu Students Welfare Forum, Tarun Bharan Singh is another association which went and filed a public interest, Goa Foundation, Indian Council for Environmental Legal Action, Buffalo Traders Welfare Association, all these organizations approach the court in order to avail remedy with respect to environmental matters. So recently the court introduced new doctrines in order to deal with environmental matters. These doctrines are recognized and added at international level. Same doctrines were incorporated in India by the judiciary to prevent and control environmental pollution. The most important doctrines are polluter pay. Person is causing pollution, he has to pay the damage compensation to remove such pollution. And every person is starting any industry, project or any plan, he has to take precautionary principles. And court evolved one more important principle, that is public trust doctrine. This doctrine was evolved in the case MC Mehta versus Kamal Nath. In this case, the court held that state is the trustee, it is the duty of the trustee to protect the natural resources. State being a trustee, state has no right to use the resources for its own benefit. Other important doctrine is intergenerational equity principles. This principle says that every person in the society is having right to use natural resources, but we have no right to destroy or damage the resources. Whatever resources available to us, we have to use the resources and we have to preserve it for our future generations. The other important doctrine is the concept of sustainable development. The court held that development and environment both are important. For the sake of development, we have no right to cause damage to the environment. Need on the part of the government and the community to maintain a balance between the concept of environment and development.